Testing 1 2 1 2. Can y'all hear me on tonight? I think I'm having a little bit of technical difficulties, but y'all come on in. Let me know where you're watching from. We have some very important business to talk about on tonight. All right, so y'all can hear me, okay? Thank y'all so much for tuning in on tonight. Yes, we are live at 5:30 on tonight. We want to talk about this story out of Robeson County on tonight. Thank y'all so much for tuning in. Before I get started on tonight, let me go ahead and just give you all this disclaimer, okay? If you're on Facebook right now and you know someone from Robeson County, Lumberton, Pembroke, whatever, make sure you tag them, let somebody know that we are live tonight. Okay. Let me give a disclaimer. Okay. The following broadcast contains commentary, opinion, and information protected under the First Amendment of the United States Constitution. All individuals mentioned are presumed innocent until proven guilty in a court of law. Okay, the content shared in this program is based on public records, eyewitness accounts, and or publicly available information and is presented for news, commentary, educational, and public interest purposes only. This broadcast may contain allegations or discussions of criminal behavior. Viewers are advised to do their own research and draw their own conclusions. Any opinions expressed by the host or guest are strictly their own and do not reflect the views of any affiliated platforms or partners. Thank y'all so much for tuning in on tonight. Y'all, we got to go to Robeson County, North Carolina tonight because there is a video that has been circulating for a couple of days on social media out of Robeson County that shows a former ex-cop, okay? And I'm going to show you who that former ex-cop is right here, Robert Walter Clark, okay? Currently, right now, he is an instructor at Robeson Community College, okay? So we're going to be talking about him tonight because there's a video, okay? In a phone call with myself, Mr. Robert Clark admitted that he beat this dog in the video. Well, he said whip the dog, okay? He said he whipped the dog and that it was a plastic thin paper whip, okay? He admitted to beating the dog, okay, or whipping the dog. We see the video. He was charged for this. Now, this incident is from 2023. A video was just dropped earlier this year about it, okay? And we're going to get all into all of that stuff. And he was charged in May for beating this dog, okay? But his charges they mysteriously disappeared. Well, we're not going to say mysteriously disappear. A judge in Robeson County said that he found no probable cause, that no probable cause was found in 21 days. These charges, were dismissed or what have you. Now, most of the time, normally in North Carolina, like even if your case is dismissed, like it gets automatically expunged, right? If a judge dismisses it or whatever, it gets automatically expunged. Where in this case, you can't even go on to Odyssey or the portal to look up criminal cases in North Carolina to even find this particular case. Okay. And I want to show y'all just let me see if I put it up here. I have a screen grab right here. So if you're just now coming in on Facebook, make sure you share the live, tag somebody. We are on a little early. Now, this right here, and to everybody that's going to catch the replay, welcome. This right here is a still shot image, okay, that police warrants said that Mr. Robert Clark beat his dog, and he did it in front of a small child, his son, okay? And I'm going to pull up the warrants in just a few moments and all of that stuff. But this video started circulating. People were reaching out to us, trying to get us to find out why this man, whose name is Mr. Robert Walter Clark, was accused of beating this dog. He was charged with it, okay? He was arrested with it. And then I found out a little bit of more information as far as his bond going from $500,000 to $50,000 and how it was some inside stuff to get his bond lowered on this initial charge. Okay. And I have all of that documentation. Well, Mr. Robert right here apparently had been going through a child custody battle between him and his wife as it relates to their child, where he was trying to get 50-50 custody. Okay. Now, during my investigation, we were able to speak to some people, we were able to gather a lot of information, court records, and all of this other stuff. And I want people to know that this is not the first time that Mr. Clark has been accused of just being abusive. Okay. Back in 2016, and I'm going to pull that up in a few moments. He was accused of using excessive force against the inmate while they were in handcuffs. He was accused of arresting a man outside of his jurisdiction. I mean, all of this stuff is public records and you can pull it up. But he has this long history of stuff. So during his, while we were looking at his background as far as the child custody case, we found out that Mr. Robert was being represented by the wife of Matt Scott down there in Robinson County. Okay. The DA who would be responsible for prosecuting this case. And let me say this, charges were brought. So you really can't be mad at the district attorney for the simple fact that the judge, but at the end of the day, when you're on the outside looking in, I'm going to get to the video. It's very disturbing. When you're on the outside looking in, right? And mind you, in this phone call that me and Mr. Scott had when we talked, he talked about how his ex-wife, or excuse me, not his ex-wife, but his wife's, they are separated, but his wife, dad, who I believe is a law enforcement officer, former law enforcement officer, had put out this video. Okay. Now, mind you, I want to pull this up here because I want to kind of give y'all a little backstory. Okay, let me see. Is this it right here? Okay, so if you look at this right here, okay, let me take the chat down. If you look at this right here, you can see that his wife is represented by one attorney and Robert Clark is represented by Jessica Burrow Scott in their child custody case. Okay. And a lot of people had concerns that maybe the district attorney, dismissed, or I'm not even gonna bring the district attorney in right now. Let me just say this. Before we knew that the judge, or before I knew that the judge, Daniel Locklear, had found no probable cause in this case, right? From the outside looking in, you have a man who is in a custody battle with his wife over their child, right? And mind you, this case was filed in what was it, March? This case was filed in March. It was filed March 3rd, 2025. Okay, 2 months before. Hold on, let me put it up right here. 2 months before Mr. Scott, before Mr. Clark would be charged with these felony animal cruelty charges against this dog, which are very, very disturbing. I'm going to show y'all. Okay. Now, when I talked to him, he were basically saying, like I told y'all earlier, that his wife's dad put it out there to try to ruin his character and all of this stuff. Okay. He got charged. Okay. But a lot of people had concerns because they felt like that Mr. Robert got away for the simple fact that Jessica and the DA, right, were married, right? And we do know that people pillow talk. Now, we're not saying that's the situation in this case, but we do know that people pillow talk. Okay. So, and the way he explained it and the way I looked at everything from his perspective, it would seem like that his wife is trying to just ruin his character because he wants 50-50 custody of their child, right? Whether that is true or not, we don't know. But the video was put out there, and he's seen on video choking this dog, beating this dog. He's charged with it. And a judge, I don't know if the judge saw the video or what the judge did, but the judge clearly said no probable cause found. And the problem that people have is the fact that did anybody, did the DA, did the wife say, man, listen, husband, tell the judge behind closed doors, that this man's wife's just trying to destroy him, to destroy his character, whatever. And the judge just, said no probable cause found and just threw it out. We don't know. But from the outside looking in, that's what it looks like. From, the people's perspective. Okay. So anyways, so I was trying to do a lot of digging, and this guy just has a lot of bad history. Okay. So let me go ahead and just show y'all the video that we're talking about. We did a story about it. A lot of people reaching out to us, media outlets, and a lot of people are commenting on it because it's very disturbing, and it raises serious questions because in North Carolina, felony animal cruelty, there's no statute of limitation on that. You understand what I'm saying? So when you watch this video, right, this man should be still pending a disposition as far as a court hearing, and how the fact a judge came to the conclusion that there was no probable cause found is just ridiculous. Look at this. Hold on. It has no audio, y'all. So now in the video right there, you see the dog is running away from Mr. Clark. You see him with the white shirt on and the shorts. Okay, look at the dog. He's trying to catch the dog. He picks the dog up by the dog's neck. Look at him. You see it? He picks the dog up by the dog's neck. He throws the dog inside of the kennel. He grabs the dog. Then he kicks the dog. Now, this is a former cop, right? This is a former cop. He goes inside of another kennel. He is doing something with that dog. Brittany King said, this is nothing new. He always gets away with stuff. Yeah, you saw him. He choked the dog, right? So he's doing something with this dog or whatever. I don't really see him abusing this dog. I don't know. I can't make out what he's doing in that kennel. So now this is their home surveillance footage dated June 27, 2023, okay? So now the cameras are switching, and he's inside of this side garage of the house, okay? Now, this is according to video that Mr. Clark admitted to, and this is from their home surveillance camera system, okay? The young boy, their child, is standing out there waiting. He comes outside. He has something in his hand, which he told us was a plastic thin whip. He goes inside. Now, according to police warrants, he went inside and dragged the dog out of the doghouse. As you can see him, you can see the doghouse. He's dragging the dog out. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 hits on this dog, okay? Now, Mr. Clark said that the dog bit his child, okay? He said that the dog bit his child. He did not provide us any proof of that at the time that we spoke with him, okay? So this video was put out, okay? And now Mr. Roberts said that it was a plastic thin whip. right? We don't know. We don't have the whip or whatever. That's just what he said. It's not in the court documents what he had. We can't even find the case. Okay. But we were able to get our hands on the physical copies of the warrant of when Mr. Clark was charged for this incident. Okay. If you can see down here in the bottom left corner, it says that he was charged. The date of the warrant was issued on May 2nd, 2025. Okay, May 2nd, 2025, by the magistrate Thomas Espy. Okay, he was charged with felony cruelty to animals. Okay, and the date of offense was listed as 6/27/2023. Okay, and the warrants were issued by the Robertson County Sheriff's, well, by the magistrate Robertson County Sheriff's Office. Okay, now when you go to you read the warrants, right? It said, now this is what the warrants say. The warrants say, on or about the date of offense shown and in the county named above, the defendant unlawfully, willfully, and feloniously did, on or about the date of offense shown and in the county named above, the defendant unlawfully, willfully, feloniously did torment, maliciously, cruelly beat a black and colored dog. The defendant picked the black and colored dog up by his neck and hair area, opened the dog kennel, and then threw the dog in the dog kennel forcefully. The defendant then walks to the shelter and exits the shelter with an unknown type of belt and or whip, goes inside the dog kennel, drags the dog out of the doghouse, and then cruelly beats the black and colored dog by walking the dog with the, by striking the dog with an unknown type of belt or whip several times while restraining the dog movements by the defendant holding the dog down with his hands. The defendant did commit the offense in the presence of his minor son, and they put his minor son there. Okay. Somebody said Michael Vick served time in jail for dog fighting, but I guess never mind. Right. So, hold on. So, the case went to trial, or I don't know, it may have been a preliminary hearing, okay? But the case went to court, okay, on May 23rd, 2023, as you can see down in the bottom left corner. And Judge the Honorable Daniel Locklear said that no probable cause was found. So the judge said that no probable cause was found in this case. Although we see this man picking up a dog by his neck. I'm talking about picking up the dog by his neck, right? And then throwing the dog inside of the dog kennel, going to get whatever this whip or whatever kind of whip he had and hit the dog 11 times. First of all, also he said that the dog was not abused. What's going on, Oreo? He said that the dog was not abused. Okay, the dog was not, physically injured, right? The dog was not physically injured, okay? And so a lot of people believe that some connection with the DA's office and Mr. Clark's child custody attorney is the reason why this stuff disappeared, but we cannot verify that. But it is very suspicious that a judge, okay, looked at this case and said no probable cause found. There's no statute of limitation at all, okay? And this man who has a history of abusing his powers continues to get away, okay? Now, he was a police officer in the town of Cathridge, I believe, in Swain County. He was a deputy at Swain County and a police officer in Moore County or what have you, okay? Now, somebody said, I don't give a damn. That was excessive as fuck, and that little boy didn't seem afraid at all. His mama wasn't attending to him, following his psycho-ass dad around, shaking my head. The math ain't math, and for it to disappear, well, it makes sense, okay? Lenora says the judge needs to be investigated. He is not following the law. That's what I'm saying. The judge is definitely incompetent because How can you watch a video of someone beating a dog like that and say that no probable cause was found? Didn't even list the reasons why no probable cause was found, but it leaves people to wonder: is there judicial corruption going on? And as a media outlet, we have a right, and our job is to investigate these things and bring it out to the public. Okay. Now, mind you, let me pull up this right here. Okay. Hold on. I want to pull up this. Hold on. So I want to pull up this right here because this is from the Department of Justice, or the North Carolina Office of Administrative Hearings, okay, from 2016. Okay, now we're going to type Mr. Robert Clark's name in here. Hold on. Robert Walter Clark, okay? So this right here is from July 22nd, 2016. Okay, this is the North Carolina Criminal Justice Education and Training Standards Commission. Okay, now this was in reference to Robert Walter Clark and his behavior. Okay. Hold on, y'all. Let me make sure I got okay, so hold on, y'all. Okay, so this right here, like I said, so let's pull it up. All right, can y'all see this document right here? Let me zoom in a little bit. Okay, so y'all can see this. Okay, can y'all see what this is right here? Okay. Okay, so basically what this right here is a proposal for decision from the North Carolina Office of Administrative Hearings. Okay. And so basically, this is a recommendation that is written by an administrative law judge, okay, after a contested case hearing, okay? So in North Carolina, when someone challenges a state agency's decision, such as in this case, like denying a professional license, this is the type of hearing that a person like that Robert would file to try, to basically, get his policing license back or what have you. Okay. So in this document, let me blow it up. Wait. Somebody said, please do more digging. He has beat his son. I'm sure there's video footage of that, and DSS dismissed that case too. I did hear stuff about that. We have not received any evidence of that yet, but I'm sure we will be receiving that soon. Okay. So anyways, so if you go to this document right here, you can Google this. Okay. This is in the state of North Carolina, county of Swain. Okay. It's Robert Walter Clark, petitioner. Okay. Versus the North Carolina Criminal Justice Education and Training Standards Commission. Okay. Now, Robert filed this to fight his denial of his law enforcement credentials or certification back in 2015, I believe this was. Okay. And it was because the North Carolina Criminal Justice Education and Training Standards Commission had notified him that it had found probable cause to deny his certification as a law enforcement officer. Okay. And then he requested this hearing to challenge that. Okay. Now, it is some very, very, very disturbing allegations in this document. Okay. Now, one incident that Robert Walter Clark, the same guy, the former police officer who we are talking about right now, okay, this document is about him, okay, because he was trying to get his license as a law enforcement officer back. Okay. He didn't want to get it permanently suspended, although they ultimately didn't agree with him getting them permanently suspended. They told him, or they recommended, that it should be suspended for 6 months based off his conduct. Okay. All of this stuff is public records. It's available to the public. Okay. Okay, let me go back to it. Okay, it says on April 5th, 2014, the petitioner, and let me tell you who the petitioner is, Robert Walter Clark, okay? It says on April 5th, 2014, petitioner was traveling on Highway 501 North in Carthage, North Carolina, when he noticed a large group of people gathering at a restaurant parking lot. Petitioner stopped, exited his vehicle, and began to hear profanity. The petitioner saw Charles Bryant, the assailant, who appeared impaired. Petitioner approached assailant, okay, which is Clark, and asked if he had any weapons. Assailant had previously communicated death threats to and or concerning the petitioner. Petitioner attempted to grab assailant, and when he did, the assailant tried to punch the petitioner in the face, okay, which is Robert. Oh, hold on, y'all. Dang, I got this picture up here. Hold on. Okay. Okay, so we right here. Robert attempted to grab the assailant, and when he did, assailant tried to punch the petitioner in the face, okay? It has Robert Clark here in parentheses, okay? When the assailant attempted to punch petitioner in the face, the petitioner ducked, avoided being struck. Petitioner leaned back and attempted to protect his gun and gun holster. There were approximately 12 people outside the restaurant in the parking area. The petitioner was without backup at the time. The assailant then attempted to avoid arrest, and the petitioner advised Moore County Communications that he was in a foot chase. As they were running, the petitioner observed the assailant reaching in his waistband, but could not determine what he was reaching for. Okay. As they were running, the petitioner observed assailant reaching in his waistband, but could not determine what he was reaching for. Petitioner lost sight of assailant, but could hear him yelling back at petitioner, using profanity and indicating that the assailant was going to kill petitioner. Petitioner advised Moore County Communications that he had lost sight of the assailant. Petitioner was then joined by Officer John Wesley Coleman at the scene. Officer Coleman was the senior officer at the scene. Upon his arrival, petitioner advised Coleman that he lost assailant in the woods and that the assailant had a firearm. Now, mind you, okay, up here at line 20, it says, as they were running, the petitioner observed assailant reaching in his waistband, but could not determine what he was reaching for. So if you could not determine what this person that you was chasing, that you had no business chasing, y'all. He had no business chasing this person, right? No business chasing this person, right? So it says that he couldn't determine what was in the holster, okay? Or determine what he was reaching for, excuse me. It says the petitioner lost sight, but could hear him yelling back at petitioner, using profanity and indicating that the assailant was going to kill him. So he's saying that the assailant that's running is going to kill me. This is what Robert was saying, okay? Or how this administrative judges found what he told them or what have you, okay? It says the petitioner advised Moore County Communications that he had lost sight of the assailant, then joined by Officer John Wesley Coleman at the scene. Officer Coleman was the senior officer at the scene. Upon his arrival, Robert advised Coleman that he lost the assailant in the woods and that the assailant had a firearm. So how can you say that the person you was chasing was reaching in his waistband and you didn't know what he was reaching for, but took it upon his words to lie to Officer Coleman and say that the assailant who you lost sight of had a firearm, okay? It said Officer Coleman instructed petitioner to go back to the parking lot and try to obtain statements while Coleman attempted to locate the assailant. Petitioner Robert then returned to obtain the statements, and while doing so, he heard Officer Coleman advise that he was in a foot chase with the assailant. Officer Coleman continued to search for the assailant. Coleman heard and observed assailant lying in the grass and quickly approached the subject. The assailant then fled on foot again, and Officer Coleman called on his radio, advising there was another foot chase. Assailant then began to reach for his leg, which caused Officer Coleman, which caused Officer Coleman to draw his weapon. Assailant removed his shoe, continued to run. Petitioner was not present during the portion of the foot chase. Officer Coleman reholstered his weapon and continued to chase the assailant. According to Officer Coleman's testimony, assailant then placed his hands in the air and lay face down on the ground. According to Officer Coleman's testimony, it was obvious that the assailant was worn slap out and assailant was compliant, not resistant, and assailant allowed Officer Coleman to place his right hand behind his back. Officer Coleman had assailant's left hand pinned with his leg. There were approximately 3 deputies present watching as Officer Coleman began to handcuff the assailant. According to petitioner's testimony and observation, Officer Coleman had not secured assailant hands with handcuffs, and the assailant's left hand was still under him. Assailant failed at first to withdraw his hand from under his body. Petitioner ran towards the scene, carrying a small plastic Stingray flashlight in his hand. Officer Coleman observed petitioner running into the scene really hot. So this is another officer telling on Robert, who is running back to the scene really hot. Okay. It says that Robert slid into both Officer Coleman and assailant, striking them with his shoe and further striking assailant in the head with his hand containing the flashlight. This is another example. Now, these are police officers. This is an Officer Coleman or Colin. They said he's an asshole too. Is telling in his sworn testimony in this administrative hearing against Robert or about Robert that he came in running between them, hit them with his shoe, and hit the damn assailant in the head with a flashlight. It says petitioner intended to strike assailant at that time, but not in the head. So according to petitioner's testimony, assailant then released his left arm and Officer Coleman was able to place both hands in handcuffs. Assailant was searched and it was determined that he did not have a weapon with him. Okay. Petitioner was concerned that if assailant fired a weapon, the bullet could harm petitioner or Officer Coleman, which is what they always do. Oh my God. Every time somebody reaches, oh my God, they got a gun. Are you going to kill me? Petitioner believed that assailant was armed with a weapon, that is a handgun. There were several deputies at the scene that perceived no such threat and had no cause to intervene in the arrest. So the question is, Robert, why did Robert intervene if no other officers felt that? If you had to break between 2 other officers to intervene, why them who is sitting right there didn't have to do that? It says during the time that Officer Coleman was attempting to place assailant in custody, petitioner believed that he or Officer Coleman were in danger. When one side of the handcuffs are free, the handcuff became a dangerous weapon and the officer could be struck by the loose handcuff if the subject's arm swings free. Officers are trained that if a suspect's arm cannot be secured, the officer should use a taser, baton, or firearm to secure that suspect's free arm. After the incident, Robert was permitted to drive assailant to Moore Regional Hospital where he continued to be threatening and hostile. Now, mind you, this is line 39. Okay. This is North Carolina. This is the chief administrative law judge. Okay. This is a hearing being heard before a chief administrative law judge in North Carolina on whether this man should be able to keep his license. Okay. And here on 39, it says that Robert was able to drive the suspect to Moore Regional Hospital where he continued to be threatening and hostile. He was medically cleared by the hospital staff. Officer Coleman had minimum supervisory experience and was impatient with the petitioner. Okay. In another case right here, you got that Robert went outside of his jurisdiction. Okay. Now, this is all public records. Okay. It talked about how on March 15th, Robert was alleged to have engaged in excessive force and in law enforcement functions outside of his jurisdiction and beyond the scope of his legal authority. Petitioner was working in an off-duty capacity for the Whispering Pines Police Department. Petitioner was handing out stickers at a public event in Whispering Pines. Robert was armed with his duty belt and dressed in his Carthage PD duty uniform. When petitioner finished his Whispering Pines assignment, the petitioner drove to his girlfriend's residence located at Lee Branch Road in Whispering Pines. The residence is approximately 10 miles outside of the city of Carthage. The petitioner, who is Robert Clark, y'all, was not on duty when he arrived at his girlfriend's residence on March 15, 2014. Petitioner had removed his duty shirt. At that point, the petitioner heard a loud crash outside the residence. The petitioner then observed the vehicle being driven by a guy named Ricardo Zadana, okay, at a high rate of speed and observed the accused hit the retaining wall on an adjoining property. Okay. The petitioner called dispatch and gave them his call sign of 364, and petitioner then advised dispatch of the hit and run. The petitioner entered his personal vehicle. Okay. This is what this administrative judge found when Robert, okay, filed this to contest his law enforcement license or certifications being suspended or revoked. Okay. It says that Robert got in a white Jeep Patriot and began to pursue the hit and run vehicle. It says that he observed the accused run another vehicle off the road and observed the accused vehicle riding on one rim. He observed the accused vehicles enter the city of Vaz. Vaz is outside petitioner's jurisdiction. The petitioner followed the vehicle into the parking lot of Keywick Stop in Vaz and then confronted the accused. Okay. The petitioner handcuffed the accused and placed him face down on the ground behind his personal vehicle. Officers Benjamin Haddock and Tim Blake of the Vaz Police Department responded. The petitioner was not in uniform at the time that the officers arrived. Okay, I'm paraphrasing a little bit. Okay, petitioner was not operating a police vehicle. Mind you, Robert was in his personal vehicle chasing down somebody. Okay, outside of his jurisdiction when he was not supposed to. The petitioner requested of the accused permission to detain him. Petitioner was wearing a duty belt and a vest, but had no identification, which would indicate he was law enforcement officer. When they arrived, Haddock observed the petitioner with his weapon drawn and the male subject handcuffed on the ground. Officers Haddock and Blake assisted the accused from the ground. The accused smelled the alcohol. The Vaz officers observed that the accused had another object in his mouth, which he was moving around but would not spit out. Officer Haddock then placed his hand on the individual's chest in an attempt to get the accused to spit out the object. At this point, this is when Robert placed his hands to the accused's face and throat area and continued to squeeze. So this is showing you a history of this man being abusive in some sort of way. Okay. A quarter was dislodged from the accused's mouth. The accused was charged with several crimes. The Vaz police officers were required to call EMS. Officer Blake was concerned because of Robert's prolonged grasp of the accused. Here it is. Another officer is saying in his testimony about this, I was concerned. Why was the officer concerned? He said that he was concerned because of the petitioner's, which is Robert Clark, prolonged grasp of the accused. So not only do we see him on video beating a dog, but we also see him, or we also see where another police officer gave a sworn statement in a hearing about Robert's law enforcement certification, saying that he was concerned as a police officer about Robert grabbing this man's face, a prolonged grasp, okay? Grab in the face. Okay. It says the petitioner was not within his Carthage jurisdiction when he first engaged in the vehicle in Whispering Pines, North Carolina, or when the petitioner effectuated an arrest in Vaz, North Carolina. Okay. Another incident, the Gatorade incident. Hold on, y'all, because this looks like, okay, can y'all see that? This is the Gatorade incident. According to testimony of Chief Davis, officers are not allowed to leave their post or jurisdiction without prior approval from the chain of command. Petitioner left his post, okay, and jurisdiction on March 28, 2013 in order to visit his girlfriend's house in Whispering Pines. Petitioner did not obtain prior approval through his chain of command, although according to petitioner's testimony, he called Sergeant Martin Key with the Moore County Sheriff's Department and explained he was sick and to monitor his radio. Damn, boy, this is some privileged stuff right here, ain't it? Petitioner does not dispute that he left his post on March 28 to travel to his girlfriend's house. Petitioner testified that he was sick and needed ibuprofen and Gatorade. which he acquired. So you drove all the way to your girlfriend's house, leaving your post. You drove all the way to your girlfriend's house to go get an ibuprofen and a Gatorade. How many gas stations did he pass? There were at least two convenience. Oh, there you go. There were at least two convenience stores open and available to Robert where he could have purchased aspirin and a drink. Petitioner was suspended for neglect of duty and abandoning his post. The mayor of Carthage. Now, this right here is where it gets very, very interesting for me. Because if we go back to these warrants, y'all read the warrants, y'all saw the date, y'all saw that the custody battle was 2 months prior to him being arrested for beating the dog, which he admitted to on a recorded phone conversation with the North Carolina Bee. Okay. Not only that, but it is weird that his attorney in the custody battle is friends or is married to the DA. DA did the job. The warrants were brought. But I want to know what is the connection between the DA and the judge, or what is the connection between Clark and Daniel Locklear? If there's one, we don't know. But it's a good question to ask, because how did this happen? Okay, so check this out. On January 11, 2014, petitioner was dispatched and responded to a shots fired call in Carthage. At approximately 3:05 a.m., the petitioner arrived at the residence of Anthony Perserno, located on East Sunday Streets. Petitioner observed, Robert is the petitioner. Remember, he's the petitioner. He observed Anthony as belligerent inside the dwelling when he knocked on the door. Resident was swearing at the officers, Robert Clark. Petitioner Robert observed a pistol sitting on the kitchen counter and also an expended, it should probably be extended, or expended shotgun shell. Excuse me. No, it's suspended. Petitioner explained to resident that he was a police officer. Petitioner was accompanied by another Moore County deputy. Excuse me. Y'all, I'm tongue-tied today. Petitioner inquired if resident had been firing a weapon. Resident was impaired. The resident informed the petitioner that the petitioner could go inside the house and look for guns. Robert found a gun, but the resident would never admit to shooting the weapon. According to Robert's testimony, Robert inquired of Moore County Sheriff's Deputy Cameron if the resident could be charged under a city ordinance. Okay. Deputy Cameron responded, "Can you testify? Can you put your hand on the Bible and testify that you saw that man shoot a gun?" Here we go again. Do y'all see this? This is the third police officer that is challenging Robert. So what is it? What is this this integrity type thing that Robert is seeming to have a hard time with in these documents, right? In these public documents, it seems as though every officer from every incident, or from the incidents where an officer have had to step in or say they were concerned or something, it's always something weird with Robert, right? So it says, "Can you testify? Can you put your hand on the Bible and testify that you saw this man shoot a gun?" Robert said, "Well, no, sir." Deputy Cameron said, "Okay, well, how can you charge it?" Robert said, "Resident was not charged." Okay. Robert asserted that he had not been trained on whether a person could be charged under a city ordinance. So it's always an excuse, in my opinion, on when Robert gets caught, right? Just like, now it's the dog bit his child, and that was the reason why. And I still don't think that's a reason to beat a dog or to hit a dog like that. Okay. Petitioner also asserted that he was unclear how to deal with town ordinance at the time. Petitioner's incident report documented that he explained to the mayor that he could charge residents with the offense of discharging a firearm within the city. The resident, listen at this. Okay. The resident asked Robert to call the mayor. Robert did so. Robert testified, "I felt the best and safest thing to do. He's impaired with guns in the house, was to call the mayor and have the mayor come get him or come get the weapons." Now, me reading this right now, do anybody know anything about Anthony and the mayor at this time having some type of relationship? Because why would Robert be calling the mayor and then don't want people to suspect that a phone call was made to somebody else to get this judge to say no probable cause found. Now, we don't know, okay, if Robert made any calls, but with him calling the mayor directly because he felt it was the best and safest things to do because he had somebody impaired with guns in a house, and he called the mayor to come get him or get the weapons. The mayor arrived at the scene and said he would take care of it. He was going to take him and the gun and the weapons. The mayor thanked petitioner for calling him so he could secure the gentleman. According to petitioner's testimony, his concern was about the safety of the individual and the community. But what about the safety of the dogs? Do anybody care about animals, or am I the only one? Or are we the only ones that's in here right now? Okay. He said that his concern was about the safety of the individual and the community, feeling that the subject was impaired and there's a weapon inside the residence. The mayor had previously called petitioner on several occasions regarding police matters. Okay. According to the testimony, Corporal Steve Martin of Carthage PD, petitioner was not authorized to bypass. So here it is. Okay. Carthage Police Department is saying that Robert was not authorized to bypass his chain of command in order to contact the mayor regarding a criminal investigation. Another officer has sworn under oath about the wrongdoing or the questionable actions of Robert Walter Clark, the same officer, the ex-cop, who was on this video whooping a dog after choking the dog. And let me say, do you really believe, or should I really believe, a person saying, hey, now if I'm watching you pick up a dog by the neck and throw the dog in the dog kennel, do I really supposed to believe that you beat this dog with a plastic thin whip? Or how can we prove that? How can he even prove to us that it was that? Or is that something that you just handed? You understand what I'm saying? Okay, so he bypassed the chain of command in order to contact the mayor regarding a criminal investigation. Robert was counseled by Corporal Martin for 1, not seizing evidence of a crime, and 2, breaking the chain of command, and 3, failing to charge the resident with criminal offense of discharging a firearm within the city of Carthage. Okay, now we don't know where they got their information from that he discharged it, because the other officer asked him, do you have proof? Okay, now on September 13, 2013, this was an incident involving a magistrate. What I'm doing is showing you all the history, the public documented history of Robert Walter Clark, which makes sense to me as to why we see a video of him beating a dog, being charged with it, and the charges, or the judge says no probable cause found. Okay. Now it says during his time as an officer with Carthage PD, petitioner had several encounters with Magistrate Charlie Smoke while on duty. Other officers for Carthage PD and other departments had similar issues from time to time involving this magistrate. On September 16, 2013, the petitioner had a verbal altercation with the magistrate in his office. At issue was the service of certain warrants. Petitioner Robert and this magistrate became engaged in a verbal disagreement regarding the proper respect that Robert should demonstrate to the bench while in the magistrate's office. So it seems like he just thinks he can do what he want to do. Petitioner and this magistrate offered mutual apologies to each other regarding the incident. Petitioner pointed his finger at the magistrate at least 2 times. Man, bro, what in the world? Petitioner seems like you need to go to, anger management classes. Petitioner conceded that he acted improperly, and petitioner received discipline and counseling as a result of the incident. Okay. Kicking out the windows of a window, or the kicking the windows out incident. On September 3rd, now this one is crazy. So basically what he did was he had a person, a suspect, a defendant in the back of the patrol car. Okay. They said he responded to several calls of a fight between the subject and his brother. Anyways, make a long story short, this guy was in the back seat of a patrol car, the defendant was, and he was kicking out the windows, okay? It says on route to the hospital, the subject began to kick out the rear window. So, you know how if somebody, is driving up on your ass or being funny in the car or something like that, you brake check them. Well, Robert didn't brake check the suspect. What he did was, it says that he put the pedal to the floor, okay? I'm paraphrasing. And he drove at the speeds between 100 to 112 miles an hour just to go meet the backup. Listen, lucky lady, listen. I haven't even took this story to TikTok yet. Wait till it get to TikTok. Wait till all of the animal rights advocate groups see this. Wait until, this is so wrong. And the fact that there's no statute of limitation, come on. Okay. So it says the subject was breathing hard, sweating profusely, and had bloodshot eyes. Robert and McDonald placed leg restraints on the subject, got him back in Robert's patrol car, and secured him in the seatbelt. He was then taken to the hospital. Lieutenant Mabee reprimanded Robert for driving at an excessive speed and said that Robert should have pulled over and handled him. That's what I would have thought. You pull over and you deal with it, not speed up 100 to 112 miles per hour where you potentially could have had a car wreck or killed somebody or killed this defendant just to go meet the backup. Who does that shit? Who the hell goes? I could see the officer, that's being called for backup speeding to get to you, but still not at 112 miles per hour just because somebody kicking out the window. So it says on September 21st, 2013, Robert was again operating his patrol vehicle at speeds exceeding 100 miles per hour for the purpose of making a simple traffic stop. All officers of Carthage PD are provided a copy of the standard operating procedures. Okay. Now it says petitioner's relationship with the chain of command. According to the testimony of Sergeant Martin, and all of this stuff will be on our website. We will be doing another story about this because this is newly discovered information that we learned about this during our investigation. Okay. Sergeant Martin, there was noticeable tension between Robert and Corporal John Wesley Coleman of the Carthage Police Department, mainly the fault of Coleman, quote, trying to start trouble and spreading rumors. According to testimony of Sergeant Martin, there was tension between Robert and Lieutenant Robbie Mabee of the Carthage Police Department. According to petitioner's testimony, Sergeant Martin once told petitioner, you know that Lieutenant Mabee is out to get you, and he's going to try to get you fired. Lieutenant Robbie Mabee, I don't know if it's quoting him or whatever. Oh, no, this is what Sergeant Tina Shepard said. Lieutenant Robbie Mabee failed petitioner by not training him the way he should have been trained. Okay, that was that. Petitioner's performance as a narcotics officer. They talked about how he did a good job getting dope off the streets. Okay, petitioner's moral character. Petitioner's assertions of good moral character was supported by Carthage Chief of Police Bart Davis. They said Clark was very polite, respectful, honest, and had a good character. Swain County Sheriff's Officer Captain Berg said Clark is an outstanding individual. He's a good, honest man. He has sterling character. His character was outstanding. It says everyone liked Officer Clark. Petitioner served positive recommendations to the North Carolina Criminal Justice Education. So basically, it talked about just giving him a fair shot. You had the people coming out saying that, oh, he was good. He was this. He was this. He was this. He was this. He was that. He was that. Okay. It says the petitioner was honest to a fault, even to the point of getting himself in trouble with his honesty. Because guess what? Even telling the truth, sometimes the truth may hurt your reputation. But it doesn't mean people are harassing you and defaming you. Sometimes the truth just hurts, okay? It says, It says after leaving Carthage PD, petitioner was employed by Swain County Sheriff's Office. Blah 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 blah. Conclusion of law. To the extent that the findings of fact contains conclusion of law, or that the conclusion of law or findings of fact, they should be so considered without regard to the given labels. The parties are properly before the undesigned administrative law judge and jurisdiction and venue are proper in this contested case. Blah 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 blah. Okay, let's see. Okay. It says under in the case law of Rogers, an instance of conduct amounting to poor judgment, especially where there's no malice or bad faith, would not ordinarily rise to the level required to reflect a lack of good moral character. Notwithstanding, there were several findings that the petitioner at times used excessive force while at Carthage PD. These incidents arising from a lapse in judgment do not alone establish lack of good moral character. Petitioner was never charged with or convicted of a crime. These incidents may well be indicative of lack of training in the proper exercise of authority, or at least in part. Petitioner has also acted at times beyond the scope of his legal authority, granted to him by pursuing and arresting an individual outside of his jurisdiction on March 15th. However, the officers in that jurisdiction subsequently participated in the arrest, which resulted from a sudden emergency, and apparently ratified and completed the arrest, taking the subject in custody. In another incident, petitioner, which is Robert, engaged in an unprofessional interaction in a legal setting by engaging in a verbal dispute with magistrate judge while petitioner was discharging his duties. In another incident, the petitioner operated his patrol vehicle in a manner that could affect the safety of others in violation of the posted speed limits. In another incident, petitioner left his post on at least one occasion for personal business. Petitioner's untoward actions, as found here, are based upon conflicting or incomplete testimony shaded in many respects by the witness perception or relationships with the petitioner as to these events. Blah blah blah. Let me go down here to what it says. Petitioner, wait. I ain't see this now. Hold on. Petitioner is now the father of a child born out of wedlock, a fact a petitioner volunteered. In addition, the petitioner voluntarily established his own paternity when not compelled to or required to do so. However, as much as this admission of paternity is a further indication of poor decision making, it does not establish a lack of good moral character. Nevertheless, it draws attention to the findings of fact where the petitioner's girlfriend, the mother of his child, is involved. Blah blah blah. Let me get on down here. It's just basically going over everything. It says petitioner's cumulative pattern of immature and questionable conduct as found herein indicates poor judgment and exercise his police authority both individually and collectively, but these patterns do not establish lack of good moral character. Poor judgment is not synonymous with lack of good character, moral character. The party with the burden of proof is in a contested case must establish the facts required. It says the petitioner carried his burden of proof by the preponderance of the evidence to permit his application for law enforcement officer certification. There was conflicting evidence in a close case law and there was conflicting evidence in a close case in law and fact. However, Robert has shown by preponderance of the evidence that the respondent's proposed denial of petitioner's law enforcement officer certification is not supported by the preponderance of evidence on the grounds of lack of good moral character. Okay, so they're basically saying based off his character, moral character, and all the whoop, they can't suspend his license or revoke it based off that alone. Okay, but it says based on the foregoing findings of facts and conclusions of law, the undesigned proposes the petitioner's application for certification as law enforcement officer be placed in suspension for an additional period of 6 months from the date of the respondent's affirming final decision. So he was given an additional 6 months suspension of his license. Okay. Somebody said Beth is his mom. She's terrified of her own son. Now, this is just a history because every time a person gets charged with a crime and they have a history, they always bring up history, their prior records and all this stuff. Well, this is Robert Clark's history, okay? And I just want to show y'all this video again that a judge in Robeson County found no probable cause in this video. Okay, you know what probable cause is? The judge watched it. I'm assuming the judge watched this video because Stevie Wonder could watch this video and see that there is a lot of probable cause. But the judge saw this video and said, and said that there was no probable cause found in pursuing a case of felony animal cruelty against Robert Walter Clark. Okay, watch this video. That right there was Robert Walter Clark. Okay, he's an instructor at the Robinson County or Robinson Community College. He's a former cop. He was charged for beating this dog, but and this is what the warrant said. And he was charged on May 2nd, 2025. And 21 days later, on the 23rd, a judge, Daniel Locklear in Robinson County, threw the case out and said that no probable cause was found. Now, if you take that case number right there and you go and run it in Odyssey online, okay, go to ncccourts.gov and run it, it's going to be nowhere to be found. We also called the clerk's office because we wanted to see when was his next court date. Okay, now everybody keeps saying there's the full story. What full story? There's no full. I mean, he's already said that the dog bit his child. He did not provide us proof of that. And for people that are saying that we don't have the full story, what's the full story when you have a video of someone beating a dog? There's no excuse for that. There's no excuse for you going to get a plastic whip. There's no excuse for you grabbing a dog by the neck. There's no excuse for that. There's no justification for that. There's no full story to that. That dog was not on your child at the time that you did this. It'd be something different if the dog is actively biting a child and you take something and you hit the dog to try to protect your child. That is a different story than a dog running around and you're trying to catch the dog and you pick the dog up by the neck, you throw the dog in the kennel, you go out, you go in another one, you go to a side house, you come out, you go back in there, you grab the dog, you drag. The warrants said it. The warrants told us exactly what Robert Clark did. And Daniel Locklear, a judge down there, dismissed this. And I think that the SBI needs to get involved and they need to investigate this on how a judge can watch a video of a man beating a dog, admitting to it, to beating a dog, and a judge finds no probable cause. And if you don't think that's corruption, you a damn lie. We know it's corruption because we've seen where Robert has called the mayor of Carthage before, and one of his superiors said he violated policy. So he is capable of doing something that he should not do, such as probably making calls to get this thrown out. Yay, nay, no, we don't know. But at the end of the day, how does a judge see that and is thrown out? Okay. And what is even more egregious is that Robert is abusing the criminal justice system. And he went and he filed criminal charges. And y'all know I've been through the cyber stalking stuff. Y'all know I've made case law in North Carolina where a 3-panel judge ruled in my case that posting about someone on Facebook, on YouTube, on social media is not cyber stalking because you did not have direct communication with that person. You did not direct this. If this man did not call your phone, if he did not email you, and I hope that Mr. Locklear is watching, because I'm about to give him 2 case laws that he needs to give his lawyer and go ahead and or try to get a pretrial motion heard so he can get this dismissed. Because if he goes to court and the judge find him guilty, which I highly doubt, then he can appeal it and he's going to win because there's already case law. Okay. So to try to, because what Mr. Robert told me is that his wife's father did this to try to ruin his character. And I just don't agree with that because it's not the father in the video that's beating a dog. It's you. So I want to share this because I want the people to know how he is now abusing the system. So I want to show y'all this. And then I'm going to pull up this stuff that I think Mr. Locklear would love that he can use for his case. And this going to get thrown right on out. Okay. So let me put this up here because a lot of people don't know about these case laws, because a lot of these magistrates, even if you read the law for cyber stalking, you have to communicate to another person, meaning that you have to send something to that person. It has to be direct communication with them, like A and B. Okay. It's not illegal to post a video, whether it's 2 years ago, 5 years ago. It is not illegal. So let me show you what Robert Clark did. Okay. He went down to the magistrate office and he filed charges against Mr. Locklear. Okay. And this is what the magistrate wrote. The magistrate wrote that on about the date of offense shown in the county named above, that the defendant unlawfully and willfully did knowingly permit an electric communication device, a cell phone, under the defendant's control to be used for a purpose prohibited in General Statute 14-196.3, sharing a video image for the purpose of harassing, embarrassing, and inflicting emotional distress towards Robert W. Clark. This right here, y'all, is not criminal. And I've already made case law. Shout out to Duke Law Clinic that represented me in that. But this right here is an abuse of the criminal justice system, because people can just go to the magistrate and lie on you and get a warrant. Okay. It is not criminal to share a video and image of anybody. And when you read the statute that the Court of Appeals has already construed and broke down, you will learn that posting a video does not constitute harassment. Someone talking about you does not constitute harassment. They have to have one-on-one communication. They have to directly reach out to you, directly text you, directly tag you, directly call you. That's what the statute is for. And so I wanted to show this because I want Mr. Locklear, okay, Mr. James Kelvin Locklear, to give this to his lawyer so that they could use this in court against this frivolous charge, okay, because that's what it is. Now, let me pull this up. I want to pull this up because I want y'all to see this, okay? Now, a couple of years ago, I had wrote a story on a woman, multiple stories, because she had created Facebook pages of missing people, and she was using it to harass the families in a way that would arise to a civil claim, okay? And she went down, she tried to go file charges, but they were denied because they had got to the point that the cyber stalking charges weren't even meeting the elements. So it got to the point where my name had to be on a list, and it had to go through an official police investigation because of a disgruntled magistrate. Well, I went to court. The judge issued a no contest order against me. I appealed it, represented by the First Amendment Law Clinic at Duke, and a 3-panel judge threw out the case. Okay, reversed it. Okay, and this is what they said. Okay, and I want this because I want Mr. Locklear to see this. Mr. Locklear, if you're watching, it says Section 50C authorizes a civil no contest order upon finding that the victim has suffered an act of unlawful conduct committed by the respondent. Okay. The definition of unlawful conduct includes stalking, which is defined in North Carolina General Statute on more than one occasion, following or otherwise harassing another person without legal purpose, with the intent to either place the person in reasonable fear, either for the person's safety or the safety of the person's immediate family or close personal associates, or cause that person to suffer substantial emotional distress by placing that person in fear of death, bodily injury, or continued harassment, and that in fact causes that person substantial emotional distress. Harassment is defined as knowing conduct including written or printed communication or transmission directed at a specific person that torments, terrorizes, or terrifies that person and that serves no legitimate purpose. Additionally, this court has noted a distinction within the context of North Carolina General Statute 14-277.3a(b)(2) between social media posts written about an individual but not sent directly to the individual. And then it quotes the main case law, which is the second case law that I want to give Mr. Locklear if he's watching, is State versus Shackelford. Okay. Now, this is what the Court of Appeals, a 3-panel judge, ruled in my case. Okay. In my case, they stated that holding the application of harassment statute to social media posts constituted a violation of the defendant's First Amendment right. The evidence presented at the May 26, 2020 hearing consisted of a series. Now, this is the 3-panel court, okay, at the Court of Appeals, okay? They said the evidence presented at my hearing, hold on, can y'all see that? Okay, right here. Consisted of a series of printed blog articles, a series of brief video clips, and testimony from the parties. The trial court ultimately chose not to consider the video clips due to the lack of context to the entire video, which was my objection. The only evidence presented at the trial consisted of the plaintiff's testimony that the defendant had not complied with the May 26th order. In order to support a finding and conclusion that the defendant was stalking and harassing the plaintiff had the burden of presenting competent evidence that the defendant on more than one occasion harassed the plaintiff without legal purpose and with the intent to place the plaintiff in fear for her or her family's safety or cause substantial emotional distress. This could include evidence that the defendant had directed written or printed communication at plaintiff that tormented, terrorized, or terrified the plaintiff and served no legitimate purpose. Here is the part that Mr. Locklear is going to need because it's going to beat your case. It's going to straight up dismiss. You're not even going to trial for nothing like this. Here, the record reflects that the defendant posted a news blog article and a video that discussed the plaintiff. But there's no evidence that the defendant directed any written or printed communication at the plaintiff. The social media posts and articles were about the plaintiff. This is what the Court of Appeals, this is what the judges opined in my case. This is what they're saying. They said the social media posts and articles were about the plaintiff, but were not directed at her, similarly to the social media posts made in Shackleford. There was no evidence presented that the defendant directed any other written or printed communication at plaintiff prior to the no contact order being entered, because there was no evidence to support a finding that the defendant stalked or harassed the plaintiff within the definitions of North Carolina General Statute 50C. Court's findings of fact do not support the trial. A court's conclusion that the defendant engaged in unlawful conduct. Accordingly, we reverse the no contact order against the defendant. Defendant additionally argues that the no contact order violates his protected speech under the First Amendment and constitutes a prior restraint. Because we reverse the no contact order due to insufficient evidence, it is unnecessary to address the defendant's additional arguments. Okay. So this warrant that was filed on the 21st of this month by Robert will be dismissed if Mr. James Locklear uses my case law, because this case law, I used it in two recent cases. They were dismissed. This case law would dismiss it. Not only that, but State versus Shackleford is a criminal case. And he was charged with stalking and cyber stalking because of stuff that he posted online about the girl. And the Court of Appeals in North Carolina reversed it. It is not a crime to post about someone. Every day we can sit up here and post about Mr. Robert Walter Clark every single damn day if we want to, or if you want to, as long as you don't send it to him or tag him in it. Okay. Now, if he reaches out to you and engage, that's different. Okay. That's fair ground because he's coming on your page. Okay. But at the end of the day, he can file charges for this video being put up by Mr. James, but you're not going to win because it's not cyber stalking. And I really honestly think that legislators should really rewrite this law. Okay. And another thing I want to show you about cyber stalking in North Carolina. Cyber stalking statute in North Carolina. Let's pull it up. I want to show you another part about this statute in North Carolina. Down here at the bottom, man, I don't know if y'all can see that. I don't even think y'all can see that. Can y'all see this? Hold on, let me see. I think y'all can see that. Down here at the bottom, it says this section does not apply to any piece of, this is talking about the cyber stalking charges, right? The cyber stalking warrants, okay, the case for cyber stalking in subsection E, oh my gosh, how do I get this so y'all can see this? Okay, let me see if I can do this. Well, it's not going to. It says this section does not apply to any peaceable, non-violent, or non-threatening activity intended to express political views or to provide lawful information to others. This section, which is cyber stalking, shall not be construed to impair any constitutionally protected activity, including speech, protest, or assembly. Okay. And by Mr. Locklear posting this video on social media, he was exercising his constitutional right. He has not committed a crime based off the four corners of that warrant. He has not committed a crime. Okay. He has not harassed anyone. This is not harassment. Okay. And for people in the comments that saying defamation, where's the defamation? Where's the false? Where's the lie? It's all public records. Where's the lie? You have to prove that it's a lie. You can't go up here and say, oh, hey, the charges were dismissed. You can't talk about it because it's defamation. It doesn't work like that. How are you going to prove that the people knew or should have known that it was false? What is false? It's not an AI made video. It is a video that Mr. Robert has stood in comments and stated why it was put out okay, it was put out because of the custody stuff. You told me my wife is mad because I got 50-50 custody. So who cares? There's no statute of limitation when you're doing a dog like this in the state of North Carolina. It does not matter. And for a judge to say that he found no probable cause, and then this new information that we got on how his bond went from $500,000 to $50,000, and how these, phone calls in the background was made. This is corruption at its best, and we're gonna bust it open. We're gonna bust it open. So at the end of the day, Robert Walter Clark should be in jail. He should be at least be charged. He should be charged. He should be able to have his day in court, and he should be able to sit on the stand and tell a judge that this dog bit his child, and that was the reason why he did what he did, and let the judge decide then. But had it been me and you, right, beating a dog and claiming that it bit our child without me showing no proof of that, I'm gonna be like, oh man, you lying. Just put your hands on your back. You're going to jail. You're going to jail. Exactly. So I will be putting this story on TikTok, because I think people need to know about the corruption that's going on in America. Okay, the people need to know what is going on in America and what is going on in Robeson County, and how animals get abused and nothing is done about it. Nothing is done about it. There's no way. There's no way. And this, I'm sure this was a probable cause hearing to see if, Mr. Clark was going to be, bound over to Superior Court, for trial as far as being indicted. And anytime you get charged, and let me just say this to y'all, this is for anybody. Anytime you get charged with a crime, okay, ask your lawyer, tell your lawyer you want a pre-trial hearing, okay, so you can challenge the evidence to see if it even meets, the level of being transferred to Superior Court, because it's not. If I was Mr. Locklear, I would go ahead and hire my attorney and use these case laws. It's publicly available, and file a pretrial motion for dismissal based off that the Court of Appeals has already ruled that posting on social media about someone is not criminal. Okay. And so y'all know the algorithm is doing its thing, is switching up, is giving other people the chance to get out there. So, we on the WAP side this month. But at the end of the day, this man needs to be in jail. Okay. There's no statute of limitation. I can see if it was a misdemeanor in 2 years. Well, 2 years later, it has run out. But the fact that he was charged here, people don't even go to court, get charged for serious crimes like this, and 21, 22 days later, a judge say no probable cause found. How can we get that? Probable cause hearing is public records. I want to hear that call. So we will be submitting FOIA requests to get these hearings, to request the hearings, okay, the transcripts or the hearings. It should be, different courts have different types of recordings, so, but we will be trying to get down to the bottom of why Robert Clark has not been charged, or why hasn't he had a day in court for beating this dog. So we will be sending out a lot of FOIA requests. Y'all, y'all do what y'all, do. But it's Robeson County. There's always something shady going on. I love my county, but we need to get rid of. Yeah, it's a lot of corruption going on, and especially corruption tied around this case. And let me be honest with you. This is just my opinion about all of this. This is just my opinion. Not for 1 second do I not believe that lawyers and judges hang out and talk. And It's really questionable when the district attorney wife is representing someone in a custody battle where their client is accusing the father of their wife of putting out a video to just make them look bad 2 years later. And then all of a sudden you get charged. And then all of a sudden, no probable cause found. And so now we can't blame it on the DA because obviously the DA's office did their job. The DA didn't dismiss this. The judge did. The judge said no probable cause found, which is the same thing that Robert told me over the phone yesterday. And before I got the documentation, that the judge said that there was no probable cause found, right? So in my mind, it's like, well, dang, do the judge, do the DA and the judge know each other? Did Jessica hit up her husband and say, hey, hit up your buddy Daniel and tell him to listen, hit up Daniel. He's going to be over the case and tell him that my client's wife is just trying to ruin his character. He's trying to destroy him. She's trying to destroy him. She's trying to put all this stuff out on him. Listen, this video of Robert may very much well damage his reputation, but it's not defamation. Okay? The truth sometimes damages your reputation. Look at the Coldplay crap. They was out and about at a Coldplay concert, cheating, and all of a sudden, the kiss cam comes up, and y'all on the kiss cam ducking and dodging. Yes, it destroyed your reputation, but it's the truth. You were on kiss cam, hugged up with another woman that's not your wife. Yes, it cost you your job. Yes, you was forced to resign. Yes, you may lose your marriage. Yes. But is it a lie? No, because we saw it. Is it a lie that you're on video beating a dog? No. The police warrants said it. A judge dismissed it, but the file cannot be found nowhere online. So make sure y'all share this video, tag someone, let them know what's going on in Robeson County, okay? They said, you know, you can reach out to the North Carolina Bar Association as she can be disbarred. She'll lose her license because of that if it is true. I mean, but we don't know if it's true. My thing about it, let me just tell you what my thing is, and we're about to go. My thing about this whole thing is that if I'm the DA and my wife is representing someone who I would have to prosecute because of a messy child custody battle, me, myself, I would call an outside prosecutor to come in. But in this situation, charges were filed, so we can't blame it on DA Scott, but it still draws a questionable, it's very questionable that he's represented by the DA's wife and a judge finds no probable cause to this case. Okay. Now, Robert has already told us that that was not the case, but of course he could be lying. Okay. We don't know. Okay. But it is very, very suspicious and questionable that these charges were dismissed. And it's not even up there to show that it's being expunged. Okay. Some court cases, because I know when my cyber stalking case up in Charlotte got dismissed, my lawyers filed for it to be immediately expunged, and it took a couple of months, but it still showed the case up there. It showed the disposition of it, and it showed that it was in the process of being expunged. And then once it got expunged, you can't find it no more. So how did the judge find no probable cause in this video? We will continue to dig and we will continue to find out. how this come about. Okay. So I do want to say thank y'all so much for tuning in on tonight. For those who did not get a chance to tune in live, you will be able to catch the replay um, on YouTube and on Facebook. Y'all, we may be back live again tomorrow. It just depends on what we got going on. Turn your notifications on. If not, we will be live Saturday night. Okay. And I will be putting up this news story on Robert as it relates to what we have found with these public records as far as his history as we continue our investigation into why this man gets to. And the reason why I'm investigating this because these cops get away with a lot of stuff that regular people without a badge don't get a chance to get away with. And it's crazy that people can say anything to justify why they did something, and for a judge to say no probable cause, that just feels like that is just very disturbing. And I do know that Robert stated that a vet had wrote a letter or something, a letter or something to the judge and was going to testify about how he took good care of his dogs and all of that stuff. But I guess they never got to that or what have you. But we will be looking further into this. I love Together his, yeah, we're gonna look into all of that. So thank y'all so much for tuning in on tonight.